ಹೌದಾ?
ನಮಸ್ತೆ ಸರ್.
ಕೋ-ಹೋಸ್ಟ್ ಮಾಡಬೇಕು, ಮ್ಯೂಟ್ ಮಾಡ್ಬೇಕು ಸರ್.
ಹೌದು, ನಮಸ್ತೆ ಸರ್.
1 minute sir, we are on to it.
ಹೌದಾ? ಓಕೆ.
ನಮಸ್ಕಾರ ಎಲ್ಲರಿಗೂ.
ನಮಸ್ತೆ ಸರ್.
ಸರ್ ನಮಸ್ತೆ.
ನಮಸ್ಕಾರ ಸರ್.
Senior advocate and doyen of our legal fraternity, Narimanji has joined, sir.
Narimanji.
Thank you.
Sir, our Honorable Vice Chancellor, Professor Venugopal, sir.
Oh, very good.
And
Legend of the law, Narimanji. Namaskar.
Professor Rangaraju, sir. Yeah.
Rangaraju, namaskar.
Sir, join agre. Iವರು join ಆಗಿದ್ದಾರೆ, ನಾರಿಮನ್ ಅವರೆಲ್ಲ. Sir. Yeah, please.
Good evening, sir. So it's almost 5 now. So can we start, sir? Principal, sir, with your permission. Sir, you're
Wait for 2 minutes. Others also join.
Senior Advocate Mohan Kathirki is also joining. Just 1 minute, within 1 minute.
Sure, sir. No problem, sir.
Has Mr. Harinarayan joined? Any idea?
Sir, we are going to the participants list. He has still not joined, sir.
He
So
has
we are-
not joined. Okay.
Yes, sir.
Hello, Mohan.
Hello. Good evening.
Mohan,
Good afternoon.
how are
How are
you?
you? Oh, fine.
Namaste, sir.
Sir. Sir, good afternoon, sir. Diamond.
Good afternoon, Mohan.
Sir, namaskara, sir.
We see, sir, Senior Advocate Mohan Kathirki, sir, has also joined, sir.
Yeah, I joined.
Yeah.
Mohan sir, senior advocate sir, namaskar.
Yeah.
Namaskar.
Our Honorable Vice Chancellor, sir, Professor Venugopal.
Good afternoon, sir.
Shall we start, sir?
Yeah, I think so.
Okay. Rohit?
Yes, sir. So, a very good evening, everyone, to one and all present here. I'm Rohit Sharma, GA, student of University Law College, Bangalore University, and it gives me immense pleasure and honor to be Master of Ceremony for this beautiful lecture series which we are having today, because we have so much eminent scholars and jurists among with us. So now, at the outset, let me extend my humble salutations and greetings to our distinguished guests, faculty members, and all the participants who have virtually gathered here. After hosting a series of successful lectures, Team ULC is glad to host the 19th lecture of the ULC Special Lecture Series. Now, I would like to firstly acknowledge the presence of our beloved Honorable Vice Chancellor of Bangalore University, Professor Dr. K Rangarajar, sir, who is also the patron for today's lecture. Sir is a well-known academician who has distinguished academic career with 11 degrees, including law, and 2 PhDs. He's known for his simplicity. Sir, I welcome you to the event, sir.
Namaste. Namaste.
Now, it is indeed a privilege to have with us Professor K Rangarajar, sir, retired professor of civil engineering who is specialized in river hydraulics from IIT Roorkee, who will be delivering the lecture on the national and international river water disputes. And it's also a pleasure to have with us the Dean of Law Fraternity in India, Sri Fali S. Nariman, sir, Senior Advocate of Supreme Court of India and former President of the Bar Association of India, with us. Sir, I welcome you both to this event, sir.
Okay. So
now, before we move on, sir, now I request our beloved Principal and Chairman, University Law College, Bangalore University, Professor Dr. Suresh V. Naragowda, sir, to render the welcome address.
Okay, namaste to everyone, sir. Respected speaker of the day, Sri Professor Rangaraju, and Dean of Bar, and a senior advocate, and a noted jurist, Pali Narimanji, Professor K R Venugopal, sir, our Honorable Vice Chancellor, Sri Mohan Katrikiji, a senior advocate, Supreme Court of India, and our distinguished visiting faculty, University Law College, and the respected invitees, and our esteemed colleagues, president and members of the Alumni Association, and our dear students and research scholars. Indeed, we are very privileged and happy to have Professor Rangaraju, an eminent professor and expert in river waters. And in fact, he has a rare distinction of being a witness in many international water disputes at the tribunals, and indeed which were represented by none other than our honorable guest who has graced us, Pali Narimanji. And in fact, Professor Rangaraj sir is recommended by our distinguished visiting faculty, Sri Mohanji. As we heard Sri Mohan Katarki on legal aspects of international water disputes, as he has delivered a lecture on the Grand Ethiopian Renaissance Dam, Nile Basin Split Wide Open. We faculty as well as students wanted to know about technical aspects of the river dispute. So with that, in that count, we requested Mohanji to suggest an eminent professor. Accordingly, he has recommended and we requested, and he has graciously accepted our invitation, and he is with us. I extend you a very warm and cordial welcome on behalf of Bangalore University and University Law College and all the concerned. Hearty welcome to you, sir. We have an eminent guest who needs no introduction. He is a noted jurist who has contributed a lot for the evolution of the constitutional jurisprudence in the country, and Dean of the Bar. In fact, we all faculty and students had a dream to have one day our Pali Narimanji to address us. And in fact, the dream come true for all of us. We are very happy and jubilant. We are really grateful to you, sir, taking out your time despite your busy schedule and gracing the program and blessing us. And I, on behalf of Bangalore University and Honorable Vice Chancellor and all of us, and I extend you a very heartfelt welcome to this program. We have our Honorable Vice Chancellor, who is a patron of this program and presiding over the program. He is a well-known academician and an able administrator who has authored more than 700 articles, 80 books, and also he has many patents to his credit. And indeed, he has been a source of inspiration for all of us to organize series of programs in the last as well as this pandemic, as this is the 90th webinar on a particular subject. And we are really grateful to you, sir, for all your support. And I extend you a very warm welcome to the program.
Namaste. Thank you.
We have a senior advocate, and as I have told you, he is also helping us and working as a distinguished visiting faculty of our University Law College and guiding us in all our endeavors. I extend you a very warm welcome to you, sir, for this program. And we have Sri Hari Narayana, former chairman IRDA and Chief Secretary Andhra Pradesh, who is also gracing this occasion as he is invited by our Rangaraju sir. I extend him also a very warm welcome to the program. We have many distinguished invitees who are participating in this. Dr. C.S. Patil, Dean, as former Dean and former Vice Chancellor acting of Law University Hubli, and many principals and law faculty members and students across the state. I extend all of them a very warm and cordial welcome to the program. We have Sri Gautam Chandji, he is President of our Alumni Association, and many illustrious alumni members and advocates from different bar have also participated in this program. I extend them all a very warm and cordial welcome. And we have our esteemed colleagues, Professor Sudesh, Dr. Dashrath, Dean Faculty of Law, Dr. Satish Gowda, Dr. Jyoti Vishnath, Dr. Chandrakanti, and I extend them all a very warm welcome. And lastly, I extend a warm welcome to all our dear students and research scholars for this program. Thank you, one and all. Namaste.
Thank you so much, sir, Sir, can we continue?
Yeah, please.
Sure, sir. Thank you so much, sir, for rendering such a warm welcome to our guests and participants present here today. So before we move on, I'd like to give a brief of some credentials to be shared of our esteemed college, sir. So the University Law College, Bangalore University, presently offers 5-year LLB honors program and 2-year LLM program with 4 specialization branches. Our college has a proud alumni, including the former Chief Justice of India, Honorable Justice M.N. Venkatachalaya, former judges of the Supreme Court, Honorable Justice N. Venkatachala, Honorable Justice N. Santosh Hegde, Honorable Justice R.V. Ravindran, and Chief Justices and Judges of the High Courts. Former Chief Ministers and many eminent law practitioners and academicians are part of our grand alumni base. So now, before we get started, any questions on the lecture may please be posted to Ms. Hita, the co-host, and the YouTube viewers can post their questions in the comment section. We will take it up in the lecture, after the lecture, post the question and answer segment. So now, water is the elixir of life. Water is the heart of the economy, and all the national and international economic activities are directly or indirectly related or dependent on water. While water remains a boon for mankind and a necessity, the disputes associated with water continues to be a bane for the growth of the society as a whole. To analyze and discuss and enlighten us on this issue, we have our exemplary dignitary, Professor K Rangarajar, sir. I take immense privilege to introduce our distinguished speaker for today's lecture. Sir, with your permission, I'll give a brief introduction of your good self, sir. Hello, am I audible?
Yes, sir, you are audible.
Yeah. All right, I'll just go on with a brief introduction. Professor K Rangarajar, sir, is a retired professor of civil engineering from IIT Roorkee. During his tenure in IIT Roorkee, he served as the Dean of Students' Welfare, Dean of Academic Programs, Pro Vice Chancellor, and Deputy Director. He has a specialization in river hydraulics. He has been conferred with the IPEN Award by the International Association of Hydraulic Research for his immense contribution in the field. He has authored 2 books and over 150 research papers. He was the member of the Indian team in presenting India's case in the Bagihar and Kishanganga disputes with Pakistan. He has also served as the advisor to several state governments in national water disputes. He is an honorary member of the International Association of Hydraulic Engineering and Research. Sir, we are indeed honored to have you here, and we are eager to hear from you, sir. Now, I request you to kindly take over, sir.
Put the screen on the, start with the PPT, please.
Yes, sir. The host may start the screen sharing.
Yeah. Good evening to you all. No, please keep the first one only. Good evening to you all. At the outset, I would like to thank the principal, Dr. Gowda, and the senior advocate, Mr. Mohan Katarki, for giving me this opportunity to speak to you this evening. During a career spanning over 40 years at Roorkee, I had very little interaction with the legal fraternity. But during the last decade and a half, while working on river water disputes, I have come in very close contact with legal luminaries from India and abroad. This has widened my vistas and enlarged my horizons immensely. And therefore, in a sense, I am repaying the debt of gratitude I owe this legal fraternity by talking to you young students of law about the issues concerning some river water disputes. I will talk about 4 disputes in all, and I must mention that all of them are those with which I have been personally associated. So while you may get to know the details of the legal and the technical issues, you would also be compelled to listen to some anecdotes which have taken place during the hearings, because that forms part of the whole story. So with these words, I would now like to start with the next slide. Water disputes have been in existence for a long time, and in 1956, the government of India took steps to set out what is called the Interstate Water Disputes Act, according to which a high-powered tribunal is set up for each and every separate dispute. And the tribunal decisions can be challenged in the Supreme Court. As we have seen, they have often been done. I'm sure as students of law, you are very familiar with these tribunals and the Water Disputes Act. Next one. Now, I mentioned about 4 disputes I'll talk about. They are all at different levels. The first one is an inter-district dispute between 2 districts. This is the Varuna Canal in Karnataka. Then I'll move on to an interstate dispute between 3 states, Maharashtra, Karnataka, and the erstwhile Andhra, that is Andhra and Telangana of today, on the Krishna River. And 2 international disputes, Kishanganga and Baglia. Next. Now, most of the water resources projects in India involve high dams. And if you look at the issues which are involved, the first of the issues is water allocation amongst the different states. Let's say there are 3 states who want water from a river basin, and they will give their demands as X, Y, and Z. Now, if you total them, it will usually be much more than the volume V which is available. And therefore, the tribunal has perforce to make cuts from what the states demanded, and that itself becomes a sore point quite often, that we asked for so much, we only got so much less. Then the second issue is submergence upstream of the dam. Many times it may be a perceived harm to them and not really submergence occurring after the filling of the reservoir. But this has also been one of the issues which has often been debated at these tribunals. The third is the resettlement and rehabilitation. Today's generation may not know much about Sir M. Visvesvaraya, but they all know about Medha Patkar, thanks to her campaign in the Narmada Valley. So resettlement and rehabilitation is an issue, but it has been troubling people for a long time, and the tribunals have also had to deal with it. Then in recent years, the environmental issues, particularly minimum flow, because fish life is quite dependent on that, has also attracted the attention of engineers. Then there is what I would call a perceived harm. In one of the recent jobs which I did, one of the states claimed that there was saline water intrusion into the river if Karnataka were to store water upstream and use part of the water. Whereas the truth was, just about 4 or 5 kilometers from the shore was a river, was a weir, which would not permit the saline water to move up. So this was more a perceived harm which was mentioned, but in reality not a harm. But then in international rivers, there are, apart from many of these, treaty requirements, and which I'll develop on in detail when I go to the 2 disputes I talk about. Now, during the last 15 years, I realized that civil engineering or engineering itself is not adequate for the solution or the resolution of these disputes. The strategies need legal, political, and technical contributions for an amicable solution. Next. Yeah. Now, I would like to mention about the experiences with tribunals in India. In the Narmada, a decision was given in 1979 for the Sardar Sarovar Dam with a height of 455 feet. After a lot of litigation, the dam height was cleared by the Supreme Court, and the dam with a height of 455 feet was inaugurated in 2017. Please note, 38 years it took for the dam to be built or inaugurated after the original decision was given. The issues, as I mentioned earlier, were involved essentially resettlement and rehabilitation. Now, if you come to Kaveri, which of course is very well known to all of us in Karnataka, the issue was water allocation amongst 3 primary states. The decision was given after 20 years in 2007. It was challenged by all the states in the Supreme Court, and the problem appears to have been finally solved following the decision in the Supreme Court in 2018, which means again something like about 37, 38 years. Now, on the Ravi Bias, there is a tribunal which has been set up in 1986, and as far as I am aware, no decision has been made so far. Next. Now, on the functioning of the tribunals, I would like to quote directly what Mr. Nariman has said at some point. The result is that water dispute tribunals, when set up, appear to last forever, whilst they provide gainful employment to a coterie of retired judges, I might add here retired professors also of engineering, and generate work for dozens of practicing lawyers. There is no prescribed regime of how the work of a water disputes tribunal is to proceed. Interstate water disputes are ill-served by the present mechanism. The Act has not worked efficiently, nor has it inspired the confidence of party states. Next. There is, however, an example of a success story also. Indira Gandhi brought around the states of Gujarat, Maharashtra, and Madhya Pradesh in 1972 to agree to give a small share of the Narmada waters to the non-riparian state of Rajasthan. And the decision was later ratified by the tribunal in 1979. This was made possible by a very strong government at the center, and unfortunately, no other such success stories of resolution by agreement have been known, have occurred since then. Next. Now I'll come to the 4 disputes one by one. The first one is an inter-district dispute between the 2 neighboring districts of Mandya and Mysore, which lie on the 2 banks of the Kaveri River. And this concerns the Varuna Canal. Next. You can see in this picture the KRS Dam on the river Kaveri. On the left-hand side is the Vishveshwaraya Canal, the old one which was there, Vishveshwaraya Canal in blue, Vishveshwaraya Canal, yeah. And then on the right-hand side is the Varuna Canal, which was the one which was newly built. Next. Now, Mandya farmers objected to the opening of the Varuna Canal on the ground that 2 gates were provided instead of the 1 required, and the canal would thus draw double the design discharge of 1,250 cusecs to the detriment of Mandya district. Now, in reality, the code of design in India prescribes that if you have 10 gates, you must provide 1 extra, that is 11. If you have 5, you must provide 1 extra, that is 6. So obviously, as a backup for damage or repair, 1 gate required a 2nd gate to be provided. But this was wrongly interpreted as thinking that by using a 2nd gate, they will draw twice the discharge. So they went to court, and there was a lot of political pressure on the government. And the matter was in court for, believe it or not, 20 long years after the construction of the Varuna Canal. Whenever the people wanted to open the gates, the Mandya farmers would come and lie down in front of the gate, prevent the gates from being opened. Finally, in 2000, around that, the court said this is a purely technical matter, and Karnataka should call in a technical expert in the field. That's when the Secretary Irrigation of Karnataka rang me up and requested me to do the job. Well, I told him, look, there are plenty of professors in IISc Bangalore. Why are you calling me all the way from Roorkee? His reply was very interesting. He said, these are people who are in Bangalore or in Karnataka, and there is a fear that they may be prejudiced or biased in one side, to one side. And I told him, hold on, I am myself a Kannadiga, so the same charge could apply against me. Then he said, no, sir, you have been out of Karnataka for the last 30 odd years, so you will be treated as a neutral guy. So it's the background in which I came. And I came and gave dates or appointments on 2 different days to the Mandya and the Mysore people in Mysore, because Mandya is closer to Mysore than Bangalore. So I landed in Bangalore. The chief engineer welcomed with a bouquet of flowers, and then said, sir, the Mandya people are already here in Bangalore. They feel Mysore is going to be hostile. Please, you remember the word, hostile to them. And therefore, they want to meet you here in Bangalore. So I met them in the Water Resources office in Bangalore. And then amongst the various arguments they gave that, they say only this is for as an emergency measure, but they can open the second gate and draw 2,500 cusecs. Then I told them, look, there is an aqueduct downstream. Please show the next slide, which has a capacity of only 1,250 cusecs. So how can they let 2,500 cusecs into this? And their reply was, sir, they will build a second aqueduct. So this was the sort of mood in which this dispute was being looked at. Then when I looked at all the records and the model studies done at the Karnataka Research Station, I found one very interesting thing to my advantage. The model studies as well as the design showed that what we call the energy dissipator, where the energy downstream of the gate is dissipated, had been designed for 1,250 cusecs. So I argued in my report that, look, if by chance they open it for 2,500 cusecs, the whole structure will collapse. Somehow, this argument appealed to the Mandya people. And then in a meeting which was jointly convened by the minister, the Mandya people relented. And then came a day when the chief engineer called me and told me, sir, after 20 years, I have opened the gate and water is flowing in the Varna Canal. Next slide. So this is the head regulator of the Varna Canal. And so after 20 long years, the water started flowing in this canal. Next. Now I come to a dispute between 2 or 3 states. This is the Krishna water dispute. Next. The party states are Karnataka, Maharashtra, and the erstwhile Andhra Pradesh. The chronology is that the first commission, the Bachawat Commission, or what was called the KWDT-1, was set up in 1969. And they gave their judgment in 1978, relatively fast. And they had found that the 75% dependable flow at Vijayawada, that is the flow volume equaled or exceeded in 3 years out of 4, is 2060,000 million cubic feet and distributed amongst the party states by KWDT-1. Fortunately, the findings were accepted by all the 3 states at that time. Next. Then in the year 2004, the question of the surplus flows came up. After all, in 3 out of 4 years, there is more water than 2060, and that should be used. So a tribunal was therefore set up for the allocation of the surplus flows amongst the 3 states. Related to this was with the increased allocation, Karnataka wanted to raise its full reservoir level at Alberti Dam from 519 to 524. So the question was whether Karnataka should be allowed to store the water up to this level. Now, a lot of debate took place on the first issue, with which I was not personally connected. So I'll only concentrate on the second one, which is about whether Karnataka can store water up to 524.256 meters. Next. Now, this is the Alberti Dam, where, and then please move along the river Krishna upstream and go up, go up, go up, go up, go up, go up, and come up, no, even a little downstream, come downstream, come to a place called Barrage. This is the border between Maharashtra and Karnataka, which is at about 200 kilometers from the Alberti Dam. And Sangli, which is a town in Maharashtra, is about 260 kilometers from Maharashtra. So the fear expressed by Maharashtra was that if Karnataka would store water up to 524.256, water would just not go up to the border, but it would even go up to Sangli. So this was the background in which Karnataka had to present its case about the raising of the dam. Next. Next slide. So this is the Alberti Dam when the spillways are discharging the flood flows. Next. So Maharashtra contended that they would be adversely affected by submergence and sedimentation if Karnataka is allowed to store water up to FRL of 524.256 meter at the Alberti Dam, and therefore pleaded that we should not be allowed to store above the then value of 519.6. Next. So we did a mathematical model study, which is using HEC6 to determine the extent of backwater upstream of the Alberti Dam for various combinations of discharge and reservoir elevation. Next. Now, please, Rohit, here first show the line at vertical line at 0. That is where the dam is. Move along the vertical. That's where the location. That's the location of the dam. Now move along the brown line. The brown line, that is the riverbed of the Krishna. Then the red line is the water surface before the impoundment, before the dam was constructed. And the blue line is the water surface when the 5-year flood and the full reservoir level is 519.6. Go at the top of the slide, there is a figure A2, water surface profile for 5-year flood with FRL 519.6. Now I want you to note clearly that the blue line and the red line merge at about 125 kilometers, which means the backwater due to the Alberti Dam at this level does not go beyond 125 kilometers. And please note, the border is as far back as 202 kilometers. Next. So we did this for a variety of combinations. We show the two FRLs, 519.6, 524.256 at the top, 520, yeah. And then for different floods, PMF, 25-year flood and the 5-year flood. Now you come to the last column, last row. The backwater, last row, 124 kilometer, 124 kilometer, 131.6 kilometer, 124 kilometer, 152 kilometer, 151 kilometer. That means while the border is at about 200 kilometers, the backwater for all conditions, all water levels, all discharges is confined entirely to the state of Karnataka. And this is without sediment. We have not considered sediment so far. Next. Now, there was a lot of controversy about the sediment. Maharashtra used a sediment load of 1.25 acre feet per square mile per year, whereas Karnataka used 0.34 acre feet per square mile per year. And both of us had used the same set of raw data which had been collected by the Central Water Commission. Obviously, one of us had made a mistake according to the tribunal. So they, in their wisdom, ordered reservoir sedimentation surveys to be made during the tenure of the tribunal itself. Fortunately, in a period of about 2 months, the surveys were done, and they came up with a figure of 0.507 acre feet per square mile per year, based on whatever sedimentation had taken place. So the tribunal asked us all to compute the backwater with the load of 0.507 acre feet per square mile per year. Next. We did this. I will read the title heading. Change in water surface levels in Maharashtra after 100 years of operation of the reservoir for the maximum, probable maximum flood and FRL of 524.256. That's the worst condition you can envisage. And please see the second column. Right from the border to Changli, there is just no change in the water level, 0.03 meter, 0.01 meter, 0.3. So our argument, therefore, was that both in the unsilted and the silted condition, for all discharges, for all water levels, there is no backwater in Maharashtra. Next. So this is what we said, backwater confined to Karnataka territory in unsilted condition. And so even in the silted condition, and Maharashtra was not affected at all by submergence or siltation. And I'm happy to say that the tribunal agreed with these and therefore cleared the Alberti Dam height for 524.256, which was a very big thing for the state of Karnataka. Next. Now I'll come to the two international disputes. One of them I'll only very briefly discuss because I want to spend more time on the other issue, which has a lot more interesting aspects. Next. Now this is the Indus water basin. Now here you can see the river Sutlej he is showing just now, then the river Bias, then the river Ravi above that, then the river Chenab, and then go up. You can avoid the zoom at the moment. Then the Jhelum and the Indus. You can keep it small right now. Keep without the zoom. I want this without the zoom. Yeah, okay. So this is the Indus basin, which has these 6 rivers. Indus, Chenab, and Jhelum. They are called the western rivers. And Ravi, Bias, and Sutlej are called the eastern rivers. So after the partition of India in 1947, there was a genuine fear that because all these rivers flow from India to Pakistan, India could cut off the supplies to Pakistan. And therefore, at the instance of the World Bank, the two sides met and came up with the very famous Indus Waters Treaty, according to which we can do whatever we want on the 3 eastern rivers, Ravi, Bias, and Sutlej. We can build dams, store water, divert, use it for irrigation, use it for power generation, anything. But on the 3 western rivers, there are lots of constraints imposed on us. We can have very limited conservation use like irrigation or that. But practically, it means we can only generate run-of-the-river power, run-of-the-river plants with no storage, use that as for power generation only. So the Chenab, Jhelum, and the Indus have that feature that they can only be used for power generation so far as India is concerned. And the other important thing is there was a dispute mechanism set in the treaty that any design which India makes on these 3 rivers, Chenab, Jhelum, and Indus, the design must be sent to Pakistan. Pakistan must approve of the design. If they don't and say, no, we cannot, you cannot build it, there were 2 mechanisms. One was to ask for a neutral expert and his decision would be binding. The second was to go for arbitration to the Court of Arbitration. And interestingly, you will see both these because in one project it was the arbitration, in the other it was the neutral expert. Next. This is the signing of the Indus Waters Treaty by Jawaharlal Nehru and President Ayub Khan. Next. Now, I must pay a lot of tribute to Mr. Gulati, who was the leader of the Indian delegation in the drafting of the Indus Waters Treaty. When I must honestly confess that apart from my favorite P.G. Wodehouse books, which I have read numerous times, the only book I have read many times out of necessity was the Indus Waters Treaty. And every time I have marveled at what a wonderful job has been done by the drafters of the treaty. All of India's interests have been safeguarded. And we found as we were arguing the cases, how much thought had gone into the preparation of this treaty. Next. Next. Yeah. The first project which I'll discuss is the Kishan-Ganga hydroelectric project, where it was an arbitration of a dispute between India and Pakistan at the Permanent Court of Arbitration located at the International Court of Justice. Whenever we sent a detailed design to Pakistan, there would be an almost immediate objection of about 25, 26 points, practically the same on every project, virtually saying it's against the treaty, you can't build it, and therefore stop the project. We will not let you build it. So this was the burden of their song in practically all the disputes. Next. Now this particular one, first please show the Kishan-Ganga river. First show the Kishan-Ganga river. Yeah, go it, right? Yeah, 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 come back, come to, yeah, right. Then show the line of control between India and Pakistan. Line of control. Right. And now show the Kishan-Ganga Dam within the Indian line of control. The red one, yeah. And there you have a 24-kilometer long tunnel through which the water is brought into what is called the Bonar Nala. And in the process, you have a large head, and that is used for generating power just at the Bonar Nala. And let's see, the water then enters Vular Lake and goes into Jhelum and re-enters Pakistan at a more downstream point. Comes in Jhelum, it goes back to and goes to Pakistan. Take it further. Yeah, that's right. So, as usual, Pakistan said, number one, you cannot let the water from Kishinganga go to somewhere else. It has to go to Kishinganga only. Diversion from the Kishinganga is not permitted. That was the first objection. Therefore, you cannot build the project at all. The second was on our sediment management strategy. I'll talk about it in a little while. We wanted to do drawdown flushing, and they said, no, you cannot do that because the treaty does not permit it. So it is in this background that the arbitration panel was set up. 3 nominated by the World Bank, 2 by India, and 2 by Pakistan, a 7-member arbitration panel. Next. So this is the arbitration panel with the Indian delegation. In the front row are the 7 members of the arbitration panel. The lady in red is our ambassador. And I am sure you can all recognize Mr. Fali Nariman at the center. And for many of you who must have seen on the TV, Harish Salveji arguing the case of Kedar Jadhav. I think it was the same chamber in which these hearings were held that the case against Jadhav was also held. So you might have seen this room at that time also. So this was the International Court of Justice room where the arbitration took place. Next. Now I want to go over the chronology of the events. May 2010, the request for arbitration by Pakistan. December 2010, constitution of the Court of Arbitration. June 2011, visit to the Neelam project in Neelam project in Pakistan and the Kishinganga in India by the court. And August 2011, meeting at The Hague to decide interim measures. The court ruled that India may continue with all works related to the Kishinganga hydroelectric project, except for permanent works on or above the riverbed until the rendering of the war. May 2011 to 12, submission of written documents by the 2 sides. And in a limited period of 2 weeks at Hague in August, the hearing was complete. Everything was complete. May 2012 to October 2012, inspection of the KCP site by India-Pakistan team. And February 2013, the partial award was given clearance for the resumption of all works. And December 2013, the final award. Please note, May 2010 to December 2013, a little over 3 years, an international dispute between India and Pakistan was resolved, complete. Whereas I gave you instances of 30 years, 37 years, for which our tribunals had to work. And May 2018, the project was commissioned. Next. So as I said, the court, to our great delight, said the diversion is permitted and construction of the Kishinganga Dam approved. I must pay once again a great tribute to Mr. Gulati here, because he had envisaged right in 1950s that the development on the Kishinganga River can only take place through a diversion. And therefore, in the Indus Waters Treaty, there was a very specific mention that only in the Jhelum Basin diversion is permitted, which made our job extremely simple. We wanted to do drawdown flushing, I'll talk about it a little later, which the tribunal felt is not permitted by the treaty, and they asked us to adopt other means of sediment management. So our major job was done, only we had to look for other sediment management strategies. Next. So this is the completed Kishinganga Dam. Next. The second one is the Baglihar Dam on the River Chena. And here, a neutral expert, Professor Lafitte from Switzerland, was appointed by the World Bank to adjudicate on this dispute. Next. Please show the Chenab River flowing from right to left. And then the dam on that, the dam axis, from there we go, yeah, come down, come down, come down. This is the dam, the Baglihar Dam. And then go to the right and show the 2 power intakes. These are the power intakes which supply the water to the hydroelectric plants. And they are located at a distance of about 200 meters from the dam. I'll come back to this figure much later. So please remember the power intake is located about 200 meters upstream of the dam. Next. Now, in blue is what you see was the main bone of contention between India and Pakistan. These are what we call the sluice spillways or the gated spillways. And the sill level of this was 808. Please show that. That is the bottom of the gate. And the intake of the power channel is at about 818, about 10 meters above. The purpose was to see that the sediment is all flushed out by the sluice gate and clear water enters the power intake. So Pakistan objected to this very greatly, to the sluice gate. They said, no, you cannot provide this. The treaty does not permit it. And therefore, they said the whole of the design of the Baglihar is in violation of the Indus Waters Treaty. Next. Now, having said that, they also conveyed it at the highest level. In a meeting between Mr. Manmohan Singh and President Musharraf, Mr. Musharraf conveyed to the Prime Minister their fears. They were like this: India can deprive Pakistan of natural flows at Baglihar for up to 26 days during low flow season by first draining the reservoir below the dead storage level to the sill level of the proposed gated spillway and subsequently allowing the reservoir to fill up. So they said that is why we don't want India to have a gated spillway. Second, they said the current design of the project allows India to release 16,500 meter cube per second at any time of its choosing, not when it's flooding. Because you have stored the water, you can open the gate, you can cause us an artificial flood. Third, that Pakistan has every right to be apprehensive of India's intentions and interpret its motives uncharitably as per the spirit of the treaty. All these had been conveyed to our leader of the delegation by the PM office, and therefore it was our job to see that these were adequately answered during the hearings. Next. Now, what was the synopsis of Pakistan's demands? The maximum flood discharge was 16,500. Pakistan said it would be 14,900. The freeboard was 4.5, and they said no, it should be only 1.1. If you come to the bottom, well before the tribunal, the hearing started, we had ourselves offered to them, yeah, we can make it 3 meters, forget about it, don't worry too much, but they didn't accept it. Now, pondage was, we wanted 37.5 million cubic meters, and 6.22 is what Pakistan wanted. For the benefit of law students who may not understand pondage, I'll just say that this is also storage, not to take care of flow variations, but to take care of load variations. And mostly pondage is talked about in a weekly sense, not an annual sense, which storage is done. The level of the power intake, 818 we wanted, and they wanted 822. But the biggest, we wanted a gated spillway with the sill at 808 meters. Pakistan said, no, we don't want them to have gates, no control, ungated with the sill at 828 meters, 20 meters above. So I'll concentrate during the rest of my lecture only on the spillway portion. The others were relatively minor. They were also argued very vehemently by us. So I'll not talk of those in this lecture. Next. Now look at the chronology here. May 2005 was the appointment of the neutral expert. August 2005, memorial submitted by Pakistan. Working on this project widened my sort of dictionary in the sense, because the only memorials I knew were the Chaudhary Memorial or the Victoria Memorial, which were monuments. And I realized that you lawyers use a different word, another word for the memoranda as memorials. So that was the first time I learned about this word. And just 1 month for India to reply to that, the counter memorial was submitted in September 2005. 1 month later, the teams visited Baglihar and the Irrigation Research Institute in Roorkee, where a physical model was there. January 2006, the limited time, Pakistan gave its reply. In 2 months, these were huge volumes, believe me, and we had to file the rejoinder. Then 2005 to November 2006, series of 5 meetings in Paris, Geneva, London, and Washington. And in February 2007, less than 2 years after the starting of the appointment of the neutral expert, the determination of the judgment had been given. Again, contrast this with the time which we have been taking in the resolution of our water dispute. And in October 2008, the dam was commissioned. Next. Now, these are the delegations of India. At the center, you have Professor Lafitte. On his left is Mr. Harinarayan, the leader of the Indian delegation. On his right, Mr. Ashfaq Mahmood. On the right of Lafitte, Ashfaq Mahmood, the leader of the Pakistan delegation. And on the left-hand side, I want to point out 4 Europeans or Americans for their left-hand side. Yeah, go left, go left. Mr. Crawford, Wordsworth, Annandale, and Ray. While we fought our own battles, the Indians, the entire thing had been totally outsourced by Pakistan. The technical people were Annandale and Peter Ray, and the lawyers were Crawford and Wordsworth. Whereas we had only one Danish expert on mathematical model making to help, but the rest of the job was done totally by the team of Indian experts. At this point, I would also, because people would be very keen to say, how was the atmosphere during the meetings and so on. We sat of course on 2 different sides of the neutral expert. But lunch, tea, etc. was all together. So Urdu and Hindi are not very different. So we would converse in these languages. And the atmosphere was very cordial, although we were arguing against each other once we entered the conference hall. And I must also pay a tribute to Mr. Nariman at this point of time, because he had a very difficult job of coordinating it, because each one of us experts has his own ego and we think we are always right. And he did a marvelous job of building a consensus amongst us. But what I remember most about him was when we had the rehearsals, and the presentation on pondage was not really all that zippy. I mentioned it to him that maybe we need to improve it a little and maybe do a little bit of that. 2 weeks later, I go back to Delhi for the next set of rehearsals, and I found he had taken over the presentation himself. Although his background is in history, educational background. He did such a wonderful job of the presentation. I was compelled to tell him, sir, I'm envious of you, because with my engineering knowledge, I would not have been able to make such a presentation. And Mr. Reddy, former secretary who was there, he said, Rangaraju said he's just envious. I want to tell him if I graded him on a 10-point scale, I would give him 10 out of 10. So if Mr. Harinarayan is here listening, sir, I have been saying this in all previous lectures, not just because you are here today. Next. Now, the very fundamental thing on which India and Pakistan disagreed was the importance of the preamble. I'll first read the preamble and then tell you what the issue was, because I have loved this preamble. The government of India and the government of Pakistan, being equally desirous of attaining the most complete and satisfactory utilization of the waters of the Indus system of rivers, and recognizing the need, therefore, of fixing and delimiting, in a spirit of goodwill and friendship, the rights and obligations of each in relation to the other concerning the use of these waters, and of making provision for the statement in a cooperative spirit of all such questions as may hereafter arise in regard to the interpretation or application of the provisions agreed upon herein, have resolved to conclude a treaty in furtherance of these objectives. Indian side said any clause, any provision in the Indus Waters Treaty has to be seen or interpreted in the context or in the spirit of this preamble. Pakistan knew that it would be totally against their interest. They said, no, please keep the preamble separate. It has nothing to do with it. Just see the clause and what it means, that's all. So it was in this background that our legal team had to make the arguments and see how best the preamble was drawn into the picture. Next. The relevant clauses which are important, I quote here, Pakistan shall receive for unrestricted use all those waters of the western rivers which India is under obligation to let flow under the stipulated provision. Second, the annexure D, volume of water received in the river upstream of the plant during any period of 7 consecutive days shall be delivered into the river below the plant during the same 7-day period. We are not obliged to do it day by day, but over a period of 7 days, we have to give them the same amount of water. And the volume of water delivered into the river below the plant in one period of 24 hours shall not be less than 50% and not more than 130% of the volume received during the same period. That means we cannot flood them, we cannot starve them of water. Next. Now I come to the India's case, the legal issues which are presented by our team of lawyers. The first of these was to say that there was violation of treaty only if Pakistan does not receive for unrestricted use all those waters of the Western Rivers. This was most beautifully argued by Mr. Nariman. And I recall when we were doing the rehearsals in Delhi, after each of us talked about the structure which we were dealing with, he would ask us one question: does it come in the way of unrestricted use of the waters of the Western Rivers? And when we said yes, he would register it in his mind. So he told the neutral experts, once this is guaranteed, there is no violation of treaty at all. The question of whether a gate is too high, too large, too small is for you to, as an expert, to decide. You say it's too big, we will reduce it. You say it should be too high, too low, we will abide by that. But please don't say that the design is such that it violates the treaty. So it was beautifully argued on this score. Then look at the other points made by our legal team. Track record since 1947, no instance of withholding water or creating artificial flood, despite 3 wars. And if India had malified intentions, we could have always flooded them through the eastern rivers, on which we are free to do what we want, which it has not done. Can I go to the next slide for a moment? You please show the Ravi, Bias, and Sutlej. Ravi, Bias, and Sutlej. These are the 3 eastern rivers on which we are free to do whatever we want. We could empty the Bhakra Dam and flood Pakistan. So we said we have not done it. So where is the question of our doing it on Chenab? And right now, when we are on the slide, show the rough location of the Baglihar Dam, which is somewhere near Ramban. Yeah, Ramban, somewhere. And between there, that and the border, the river Chenab has 90 kilometers in India. 90 kilometers in India. Okay, next, go back down. So we have not flooded you through the eastern river. So why do you think that we will do it now? Then a very important point was that treaty has to be interpreted in good faith, which emerges from the late Lano arbitration between France and Spain in 1957. You entered into a treaty in good faith. Now you cannot say you don't trust them. So Pakistan is not justified in interpreting the treaty through lack of faith. Then, as I said, there is a 90-kilometer reach of the river downstream of Baglihar in India, and any artificial flood which they said we would cause is more harmful to India than to Pakistan. Next. Next. So with the reduced storage after sedimentation, India could, if it so wished as alleged, hold back the river for just about a day and not 26 days as feared by Pakistan, and holding back by a day is always permissible. Then in our report or in the presentation, we drew attention to these very important phases of the treaty. Being equally desirous of attaining the most complete and satisfactory utilization of the waters of the Indus system. Spirit of goodwill and friendship, cooperative spirit, sound and economical design, and satisfactory construction and operation, customary and accepted practice of design. We said words like security, conflict, motives, which Pakistan used in its memorial, just don't find mention in the treaty. Next. Next, yeah. The neutral expert indicated his agreement with the above tenets through the following statement. So total agreement with what we said. Thus, the preamble, as it fixes the common intention of the parties, should play a role in the interpretation of the rights and obligations under Annexure D of the treaty. The interpretation of the treaty should also be guided by the principle of effectiveness. This principle means that treaties are to be interpreted with reference to their declared or apparent objects and purposes, and provisions are to be interpreted so as to give them their fullest weight and effect. Therefore, the treaty permits the use in the construction and operation of the project all latest technological development. India cannot be shackled to the technology of 1960 because the treaty was drafted in 1960. They have every right to use the latest technology. And finally, he said India's design is not violative of the treaty. Next. Now I come to the gated spillway, the last of the topics I have in mind. Now, Pakistan was saying ungated spillway. Now let's see what the problem is. The maximum water level of the reservoir cannot exceed 840 meters to avoid flooding of Puldoda town, as well as an infrastructure which is a bridge upstream. If the design flood should occur, the spillway gates would be opened and the reservoir level would not rise above the full pond level of 840. On the contrary, if the spillways were ungated, the water would rise about 12 meters above the spillway crest because of the short length of the dam. To avoid upstream flooding, the crest will need to be fixed at 828 meters. The 130-meter head of the power plant will be reduced by 12 meters, which would represent a loss of 9% energy production throughout the life of the plant. So he said, I don't want this to happen. If protection of Kuldoda town is not considered, maximum water level could be raised by 12 meters to 852 meters. No energy production would be lost, but the cost of the dam would be significantly higher because you are building a 12-meter higher dam. This is a purely economic consideration with regard to the population of Kuldoda. Next. Now he gave a beautiful argument in favor of the gated spill, which we should have done, but he did it. See the last of the pillars, for discharges greater than 14,000, 83.8% of the dams built in the world have gated spillways. Only 7.8% have the ungated spill. He went further. Next slide. For discharges greater than 15,000, please note our discharge is 16,500 at Baglia. Come to the last column, 95 to 2001. See that in the world, 28 spillways have been gated, and there is only one ungated. And in the report, there is a huge, large discussion as to why this had to be ungated. So the world is therefore building gated spillways. So he said, if the world is building gated spillway, how can I ask India to build an ungated spillway in the year 2010? So that's how, without consideration of sediment, only for the flood, he said India should build a gated spillway, period. Next. Then comes the issue of sediment. I mentioned about drawdown flushing and pressure flushing. One way is not to lower the reservoir, keep it wherever it is, open the gate, and then only a small amount of sediment, Pakistan said, will be flushed out between the gate and the sediment mound. Can you show that? Between the gate and the sediment mound. That's the only sediment which will be removed. Whereas if you draw down the water in the next slide, then a lot more sediment will go out, as you can see. And so Pakistan said the treaty does not permit India to draw it down. And they're saying they will flush by the first technique, that is the pressure flushing. And they cannot do it. So the sediment management is not going to happen at all. So we had to show that even without the drawdown, we will be able to do flushing of the sediment. Next. So how did you do it? The first thing was we showed an example from a dam in China. You can see on the right-hand side is clear water emerging and coming at a much higher elevation, which means the water level is very high. There is no drawdown. And see this lower level sluice, it's at low level, and see the highly sediment laden water. So we said, look, drawdown is not required, and still you can eject the sediment. That's number one. Next. We had a very intelligent young man in 100 Gardisal from DHI, and he one day sitting in the lounge in Paris Hotel said, sir, I want to try something. And I go ahead, and what is it? He said, sir, I'll impose a landslide into the reservoir. So the blue line, that's the landslide into the reservoir. And mark 818 on this figure. Yeah, up to the level of the 818, that's the power intake. He said there is a landslide. And mark 200 on the left-hand side. Yeah, that is where the intake is. So he said so much sediment is there. And now I will operate through the model. The gate will be opened without lowering the reservoir level and see what happens next. Now you can see the pink line is what happens after the operation of the gate. Please see that at 200 meters, practically all the sediment is gone. And the gate, the intake is at 818 meters. So we said, look, even without drawdown, there is removal of sediment. It had happened in the reservoir in China. Therefore, this will work. So the gated spillway is good for flood. It's also good for sediment. Next. Now, the neutral expert had asked a question about when you can say management of reservoir sedimentation techniques had emerged. So the aim was quite simple. Pakistan wanted to say everything was known prior to 1960 when the treaty was drafted. And we wanted to say everything became known after 60. So that when the treaty was drafted, it was not known. So this particular line, a rational approach, I'll read it. I wrote it myself at that time and might have taken 10 minutes to write that, but I didn't expect that to be the center of so much discussion later. A rational approach to management of reservoir sedimentation and design of related hydraulic works may be said to have emerged after 70s with the advent of mathematical modeling of morphological processes and the awareness of the need for integrated sediment and water management in case of alluvial streams carrying heavy sediment loads. Now, Mr. Arundale had said everything was known in 1936-40 itself, so nothing is new. So the treaty knew what they said when they said you must have an ungated spillway. But look at what the neutral expert said. The conclusion of Professor K Rangarajar from India was clear and similar to that of the neutral expert. The conclusion of Professor G.W. Arundale, expert of Pakistan, was that today the current generally accepted techniques to manage reservoir sedimentation were already known and implemented in 1936. This is not correct, but incomplete. I must mention that this is the only place in the whole report where names are mentioned. Everywhere else, it is India and Pakistan, and there was a reason for it. The reason is as follows. The draft judgment, as per the World Bank practice, was read out by Professor Lafitte, and Pakistan were devastated because in the draft report, he said, India will build a gated spillway. So there was such a furor. Their expert Arundale got up, put up a series of transparencies, telling the neutral expert, you said this, now you say this, please explain how you arrived at this decision. There was stunned silence in the hall, and the neutral expert went red. And even the Pakistan delegation was on the verge of a walkout. They were fortunately restrained from doing so by Mr. Crawford. And the neutral expert went red, and then immediately Mr. Nariman came to his rescue. He said, this in legal parlance is called cross-examination of the judge, and this cannot be done. So immediately, Mr. Lafitte recovered, and he said, I will not answer you at this point of time, but I'll answer you at the right time. And this was his answer. He wanted Arundale's name to come. Brutus, in his very famous funeral oration, said, not that I love Caesar less, but that I love Rome more. I can make a slight modification of that and said, not that Professor Lafitte loved Rangarajar more, but that he loved Arundale less, which prompted him to write this. Next. So what did the neutral expert say? Look at that. Number, size, and level of the base of the sluice spillway are consistent with a sound and economical design and satisfactory construction and operation of the works. In fact, the outlet should preferably be located 8 meters lower, that is 800. Pakistan wanted it at 828, and he said 800. Unfortunately for us, we had already started building the dam. It didn't stop during the period of the tribunal, the hearing, so we could not take advantage of it. Now look at the next one, which came as another shock to them. Sound operation of the outlet will necessitate carrying out maintenance of the reservoir with drawdown sluicing each year during the monsoon season. It is commonly agreed in practice that maintenance is an absolute necessity with its ultimate objective of ensuring the sustainability of the scheme. The reservoir level should therefore be drawn down to a level of about 818, that is to say 18 meters below that of the dead storage level. We had not asked for drawdown. He gave it to us. He said, you must do it in the interest of the project. Next. So finally, what happened? 16,500 was our discharge. He said yes. Freeboard, he said 3 meters, which is what we had already agreed upon. Now, pondage, we wanted 37.5. He gave very close to that, 32. But the only one where he came to close to Pakistan was in the power intake. He gave 821. Pakistan wanted as high as 822. We wanted it 880. But the biggest shock to them was that gated spillway with the sill at 818, 808 was given instead of what Pakistan wanted at 828.2. Fine. Therefore, next. The dam was built. as I said, in 2008. Next. This is another view. And so it was a great moment for all of us who are associated with this project. Next. Thank you all for your patient hearing.
Okay, sir. Thank you. Thank you very much, sir, for your very informative and brainstorming lecture. And
Thank you.
indeed, we all faculty and students and all the people who have joined this platform are highly benefited by your very informative lecture. And question answer we will take up at the end. And it is our earnest desire of all the faculty and students to request Honorable Pali Nariman sir to kindly address us, as Pali Nariman sir's contribution and help to the state of Karnataka is immense, as he has represented Karnataka in Kaveri and Krishna, which are lifelines of Karnataka, and also at the international level. We wish to hear from sir also. Thank you, sir. Kindly, sir. Nariman, sir.
Oh, I don't know. Am I mute or unmute?
No, you are unmuted, sir. We are hearing you. We are listening.
Yeah, we can hear you, sir.
You can hear.
It was an excellent speech.
Thank you, sir. Thank you. Coming from you, it means a lot to me,
friend, Rangaraju, and he made it extremely interesting to all of us. And my memory got revived considerably after hearing him. It was a treat to have him as our witness, both before the neutral expert as well as ultimately before the 7 judges at the Hague. And we thoroughly enjoyed his company and were considerably influenced by his technical expertise. But it only shows you how a person is able to give of his best and then recall what was his best on a subsequent occasion. And I'm sure when I go through the written presentation which is given orally today, it will certainly enlighten me and help me to remember a lot of little small details that went around, such as where the expert from Pakistan was so angry that he called the neutral expert by his surname without saying sir or without saying your honor. And ultimately, the man suffered for it because the report was not very helpful to our opponent. But whatever it is, the importance of an expert in a water dispute is something which everyone must be conscious of and has to be highlighted, because these are very technical matters. And we got the most ample assistance from Rangaraju during our interaction with him at The Hague. So far as the report is concerned, both the report of the judges as well as the report of the neutral expert is something which, to those students of water disputes, would be well advised to peruse before they put their questions to Mr. Rangaraju. So I would seriously suggest that, and I will be very happy to listen to all the queries that come, but it would be more interesting to have Mr. Rangaraju record his answers in writing at a subsequent stage, which can be certainly distributed by the organizers of this very fine presentation. So my congratulations to Rangaraju and my congratulations to the host organization.
Thank you, sir. Thank you very much.
Thank you, sir. Thank you very much for your valuable address and advice to all of us. We are really blessed by your presence today. And indeed, Sri Mohan Katarki ji, our own person from Karnataka, he also worked in the team of experts who have represented Karnataka to handle Kaveri and Krishna dispute, which is led by Pali Nariman ji. We wish to hear from him also. Kindly speak a few words on this subject.
Yeah, thank you, Suraj. At the outset, may I congratulate Mr. Rangaraju for his excellent presentation. Also, congratulate Nariman the way he summed up after the Rangaraju lecture. Sir, we have not met you for a long time. During the COVID, we always feel very sorry that we have not been able to meet you, because in my life of 30 years in Delhi, not a single month passed without meeting you. And for the last almost 14 months, I have been suffering the fact that I have not been able to meet you and get one or two scoldings that you have not done this, you have not done that, get it done. Because Nariman's style of working is something which I have not seen any other advocates to work. It's a great pleasure to work, because every time we go to him with full preparation, but we come out from his chamber thinking that I was not able to tell what I wanted to tell. But at the same time, I'm sure he would have extracted all that I wanted to tell in his own way. But that is the art of Nariman, how he used to function, and we all really learned a lot from him. Professor Rangaraju has been a witness for state of Karnataka in Alberti dispute. Alberti dispute, that Alberti Dam construction posed two challenges. One is the challenge from the downstream state of Andhra Pradesh with regard to the injury which they allege would cause if the state builds a dam of 24.256 meter. The other is Maharashtra's problem of submersion. Rangaraju was a witness for the state of Karnataka to depose, as he has already explained, that even after construction of dam up to 524.256, there will be no submergence either in the still water condition or in the dynamic condition, that is backwater effect, and further in the silted condition also, that is when the siltation occurs after 100 years, still there will not be any submergence. He very beautifully enunciated a principle that the backwater line is determined finally by applying a principle whether there is a change in the velocity or not. The point where the water velocity does not change, dissipate, I remember still, that is the point where you say that the backwater ends, right, sir? If I remember. And that is how, and also seeing Rangaraju appearing against me, when she was advising the state of Andhra Pradesh in Vansadhara water dispute, where I used to appear for the state of Odisha. And it was a pleasure looking at him, and particularly the cross-examination of the witnesses and all. Oh, he didn't appear in the as a witness, but he was there to advise the state of Andhra Pradesh. And we all had to be very careful every time to, while preparing that, what could be the advice of Mr. Rangaraju to the other side and how the witnesses will prepare. So it has been always a great pleasure to listen to Rangaraju. His art of presentation used to be beautiful. The way he used to speak in the tribunal, the way he used to address the queries. And this is something which very few experts are able to answer the questions. As far as my experience, the water dispute goes, most of the experts find it difficult to fathom the question and then answer. But Rangaraju had a great style of understanding the question and very briefly answering it in such a way that there used to be no supplementary questions on the point. So thank you, sir. And we really enjoyed your today's presentation. And particularly the international dispute, I have not read much about it, except that I glanced through. But now with the help of technical briefing, which you have given today, I'll again read. Maybe hopefully I'll write some article or some note on this water dispute, because both Kishangarh and Baglihar have not been yet analyzed by any legal experts in any of the journal I have come across. So I'll try my effort to prepare some sort of a case analysis on this. Thank you very much.
Thank you.
So thank you, sir. Thank you very much for sharing your memories. And in fact, for all your help extended to us in the University Law College to get all the eminent speakers in this platform. And thank you very much. And now with this, I request our Honorable Vice Chancellor kindly to give his remarks. Afterwards, we will take up the question and answers. Shall we do that, sir? Yes, sir.
Yeah. I will. I'm not an expert. I am very happy indeed that Professor Rangaraju and the legal legend Fali Narimanji, then we have Mohan Katarki, all being on the same platform here with University Law College. In fact, being a computer science engineer from Vishweshwaraya College of Engineering and being the principal of that college, and Vishweshwaraya being a great civil engineer, I had only heard of names. And today we are very fortunate that Professor Rangaraju has given an excellent presentation, and his presentation was so concise that we are able to, was able to pick up few jargons, especially with like backwater, sedimentation, power generation, height of the dam. And when it comes to the disputes, especially with respect to Kaveri, Krishna, and many other disputes in this country, water disputes. Like water has been always disputed. A number of disputes have arisen in this country. Whereas in Egypt, there is a Nile River, and in America, there is USA, there is Amazon River. But in India, we have rivers everywhere and we have disputes everywhere. More the number of rivers and more the number of disputes. And whatever Professor Rangaraju was saying about whether it is Alberti Dam construction from 519 to 524, or whether it is the Indus Valley, this thing, and Kisar Janja and Baglihar, disputes between India and Pakistan. This has been an eye-opener for me as a computer science engineer. And the core point is the persons who are arguing for our country, especially Fali Narimanji, who has been so, in the forefront of arguing these issues for our country and making it useful, and we are being, finally, it has been on our side. Thank you very much, Sir Fali Narimanji, for arguing with us. Thank you very much, Rangaraju, for your light and concise presentation. And Mohan Kataki has been here with us for so many times with Karnataka, and also Fali Narimanji with us. And we look, all three are looking like Kannadigas for me, and because they have been fighting cases for Karnataka. Thank you very much. And thank you, the Government Law College, University Law College, for giving me an opportunity to address you, especially Suresh Nadagoda, Sudesh, Dashrath, Satish, Jyoti, and Chandrakanti, and all the viewers who have now been able to grasp these water disputes in the country with the enlightened speech of Dr. Professor Rangaraju. Thank you very much.
Thank you, sir. Thank you very much for your brief remarks. And with this, now I request Mr. Rohit to kindly take up the questions.
Sure, sir.
Yeah.
So with your kind permission, we'll move on to the question and answer segment now. So the first question goes as this, sir. Pandit Jawaharlal Nehru once said that dams are modern temples of India. Could rivers be made a national asset to solve a lot of problems? This is the first question, sir.
Good.
I will repeat the question once again, sir, if you want. Pandit Jawaharlal Nehru once said that the dams are modern temples of India. Could rivers be made a national asset to solve a lot of problems in India?
What does declaring it as a national asset imply? What does it imply? That means only the country as a whole can decide what is to be done, and the region itself has no say, or what is the implication of that being declared as a national asset?
Actually, there is no special mention or specific scope mention of what a national asset means here. It's just a general question which is asked by one of our viewers.
No, because you see, it is treated as a national asset, even though it may not be pertinent to the country as a whole. But if you see the working of any tribunal, the attempt is always to optimize from all angles what is the best for the region in which this river is flowing. So in that sense, it is indeed treated as a very valuable asset.
Thank you, sir. So the next question goes as this, sir. Can it be said that interstate water disputes are not resolved quickly through the legal mechanisms due to the lack of political willingness and other political compulsions?
I would not put the blame on any one person. It's the system as a whole. All of us are to blame, whether the engineers or the technical personnel, the lawyers, the politicians. So, but the thing is that when I showed the chronology of events in the international disputes, somehow they have managed to reduce the gaps between hearings and so on. People are given limited time. So I don't know the hurdles in following that practice in our country. There must be, obviously. But I think the lesson from it all is that at least we can expedite much more than we are doing at present. We may not be able to solve a problem in 3 years, which we did in Baglihar, but certainly much less than 30 odd years, which we have been taking.
Sure, sir. So the next question goes as this. Can it be also said that in international disputes, probably such political compulsions do not exist and disputes are resolved faster?
Why do you say political compulsions do not exist? Each country delegation has to go back and report to its government what's happening. So there is you cannot say there are no political compulsions.
Thank you, sir. So there is next one other question.
Small
Yes,
request, you please announce the name of the student or somebody who has asked the question.
Sure, sir. The questions I had received till now didn't have any names. So if at all I get the names, I'll just announce them, sir. So the next question is by on Mr. Martesha GS. Sir, is it possible to link Ganga, Kaveri and many other rivers as linkages to benefit the needs of southern states, especially in Karnataka, in southern districts which are facing drought problems? And if possible, what are the advantages and adverse effects of this river linkage? And how much time it will be required, if possible, for establishing the river linkage?
The interlinking of rivers has been talked about now for decades. And several of these task forces have been set up. And there are many hurdles. There are several issues which I'm not going to. But at the moment, the only link which you can say is possible is being done is the Ken-Betwa link between UP and MP. That's the only link which is there, Ken-Betwa.
Yes, sir. So I would like to seize this opportunity to pitch in a personal question on my personal note, sir.
Yeah, please.
So I would like to request your suggestion on which method of dredging is most effective, sir, for removal of sedimentation, especially since we were talking about the technicalities. I just wanted your opinion, sir.
See, I do not know the various dredging techniques available, but I must say that when I first started teaching, we used to say that dredging is uneconomical. We would just not. So we would let the reservoir silt up and then manage it. If you can remove the sediment by other means, we do it. Otherwise, the life of the reservoir was continually decreasing. The efficiency was going down. But of late, water has become so precious. There are instances of dredging which are being done. And it has associated problems, like what do you do with the dredge material? It is supposed to be contaminated. Where do you put it? So it's not a simple matter. But what was ruled out 30, 40 years ago is not ruled out. At the moment, it is being done in some reservoirs, some countries. But I don't know about the dredging machines which are more suitable for reservoirs and not for sea and all that. That I don't know.
Sure, sir. So I guess that's the questions we have received. So there's one more question, sir. Just now we got it. Sir, what is your view of managing water by constituting a basin organization or as is being done in present day? This question is by one Mr. Venkatesh NH.
See, the thing is, no matter which agency you put in charge, unless there is liquid support from the local population, because the success stories which we hear about are in small areas where water harvesting has been done, lakes have been rejuvenated. They have not been done with government support. They have been done by the local population getting together. In Karnataka, we have such stories. In Maharashtra, we have such stories. So it's not necessary for us to officially have through the government order some of these agencies. And if the public has confidence in the agency which is doing it, we have seen success stories. At least half a dozen of them I have heard in the last 2-3 years.
Okay.
Yes, sir. So I guess that's the question you received,
okay,
sir.
So thank you. Anybody has any other questions? Any faculty members? Okay, if there are no questions, so thank you very much, sir. Indeed, it has been a double bonanza for us today. One is to have your excellent discourse and also the presence of Sri Pali Narimanji and his address. And indeed, we are really grateful to you for your valuable lecture and sparing the valuable time by all of you, including Mohan Katrki sir, for almost 1.5 hours. We are all highly benefited by all this discourse. So with this, we'll proceed to formal vote of thanks by Professor V. Sudesh. Please, sir.
Good evening, everybody. On behalf of Bangalore University, University Law College, and the Department of Studies in Law, it's my humble duty to propose the vote of thanks. Sir, you really made our evening good. Professor K Rangarajar, Pro-Chancellor and retired Professor of Civil Engineering, has today presented a very wonderful, a very simplified presentation on resolving or the techniques of resolving interstate river water disputes. Compliments are already paid by none other than great jurist Fali Nariman Sarji. Sir, your presentation has quenched our thirst for knowledge. Indeed, if young lawyers, students have to learn anything from your presentation, is that a lawyer must be jack of all trades and master of none. Your technical know-how, your simplified presentation has made us believe that many disputes could be solved with deep insight into the problems of resolving those disputes. Thank you so much, sir. We wish someday we could have you in our college physically to interact with our students with folded hands. I thank you once again, sir. Thank you so much, sir. I thank the legend of the bar, Doyen of Indian legal scene, Fali Narimanji, sir. Your presence here on this online platform has fulfilled our desire insofar as having you live with our students. Thank you so much, sir, for blessing us. We would, in course of time, look forward for your your lecture, your advice to our students, our budding lawyers in course of time, sir. Thank you very much, sir, for taking time off your busy schedule. Thank you so much, sir. I take this opportunity to thank the patron of the ULC lecture series, our own beloved professor, Professor K Rangarajar, sir. So you have been with us in all lectures by personally being there, encouraging all of us to bring many more such lectures. Thank you so much, sir. We are indeed blessed by your presence today. Thank you, sir.
Thank you. Thank you to all the speakers and the great enlightening guests who have been here. Thank you.
This lecture today would not have been possible without the help and support of Shri Mohan Katarke, Senior Counsel, Supreme Court of India. You are now one of our faculty. So you always think of our development, our progress, benefiting our students. I don't think I need to be too formal in thanking you. But anyhow, thank you so much, sir, for giving us this wonderful resource person, Professor K Rangarajar. Thank you once again, sir, Professor Mohan Katarke, sir. I also thank our principal, Professor Suresh Vinadgaudar, the Dean of the Faculty of Law, Professor N. Dashrath, my colleagues in the Department of Studies in Law, Dr. Satish Gowda, Dr. Jyoti Vishwanath, Dr. Chandrakanti, for making this event possible. Let me not forget all the technical experts, Sri Hari Narayan sir, and many others who have joined in to listen to Professor K Rangarajar. I thank Sri Gautam Chand, member of the Bar Council of Karnataka, alumni president, and our student for joining in us today. I take this opportunity to thank all those people, all those professors, technical experts, advocates who could not join on Zoom, but have listened to you. I have listened to today's lecture on the YouTube live stream. Thank you, each and every one of you, for making this lecture more meaningful. I'm sure today, when you sit back on a Sunday evening, you will gain a lot from Professor K Rangarajar's presentation here today. Thank you, one and all. Not to forget my dear, beloved students, LLB, LLM, all my research scholars. I think this is truly, I believe this is a once in a lifetime opportunity for all our students to get a direct insight into all the technical aspects. Suddenly, in a moment of 1.5 hours, we have traveled across the globe. We have gone to Hague, we have gone to India-Pakistan geography, our own Karnataka, the Varuna. We are wondering that a dispute at the international level could be resolved in 3-4 years. And here in our own state, it takes more than 10 years to resolve a dispute. Sir, thank you so much. Thank you, dear students, sir. Once again, to all those who present there online, thank you so much and have a very good evening. Thank you all.
Thank you, sir.
Thank you so much, sir. Thank you so much, sir, for rendering such a heartfelt vote of thanks. So before concluding, I would like to request the host to screen share the upcoming lecture series flyer. So before concluding, I'd like to announce the 20th special lecture series, which will be on 5th June of 2021, which will be delivered by Honorable Justice Shri B.A. Patil, sir, on the topic of sentencing policy in criminal justice. Do tune in on that day. With this, we conclude today's session. And I'd want to thank University Law College and Department of Studies in Law, all the faculties, and our beloved principal and our vice chancellor for giving me this opportunity to host such a great platform and such a great lecture meet, having great personalities such as Professor K Rangarajar sir and Padma Vibhushan Shri Fali S. Nariman sir. With that, thank you one and all. Stay home, stay safe. Jai Hind, Jai Karnataka. Thank you.
Thank you. Thank you, sir. Thank you one and all.